All right, so today we're diving into something that is uh, pretty crucial for anyone who's involved in construction projects in any way.
Definitely.
Delay damages. And we're going to be using as our source material today a practical guide from the Royal Institution of Chartered Surveyors, the RICS.
Yes.
Those folks. So think of them as the experts setting the standards in the field. And we're going to be talking about, legal terms, real-world examples, and, of course, all those potential pitfalls to watch out for.
Yeah, it's really interesting how often delay damages come up, and I think a lot of people don't really quite grasp what they actually entail.
Right.
So this RICS guide is fantastic, to really sort of shed some light on the subject.
So let's start with the basics. Why do we even have this concept of delay damages? What's the underlying principle?
I think the core idea is really just to compensate the party who's been negatively impacted by a delay.
Okay.
So it's about putting them back into the position that they would have been in, if the project had finished on time.
Makes sense.
Yeah.
So how do you actually measure that impact, though? The RICS guide mentions two types of delay damages, unliquidated and liquidated.
Uh-huh.
Can you break those down for us? Because those sound a little intimidating.
Yeah, so unliquidated damages, they are all about proving the actual losses that have been incurred because of the delay.
Okay.
And it can be very complex because you need concrete evidence, things like receipts, invoices, to support your claim.
It's like you're gathering evidence for a court case.
Exactly.
Yeah, you need that paper trail.
You need to demonstrate that direct link between the delay and the specific costs that have been incurred.
Right.
Now, liquidated damages, they're a bit more straightforward because they're pre-agreed amounts that are actually stipulated in the contract.
So it's kind of like a just-in-case fund built into the agreement.
Yeah, that's a good way of thinking about it.
Yeah.
It offers certainty and avoids, those lengthy disputes over proving losses. But there's a catch because the pre-agreed amount may not fully compensate for the actual damage, or it could actually end up being more than what the actual losses are.
Interesting. So with unliquidated damages, you might end up spending a lot of time and effort proving your losses.
Yeah.
But you could potentially recover the full amount.
Yeah.
With liquidated damages, it's simpler and more predictable, but you might not get fully compensated. Yep. Or you could overpay. So it's almost like choosing between taking out insurance or setting aside a fixed amount in a rainy day fund.
It is a great analogy. It really highlights the trade-offs involved, with choosing one over the other.
Now, the guide also mentions that liquidated damages can't be a penalty. So what does that mean exactly?
Well, it basically means that the amount that's agreed upon has to be a genuine pre-estimate of the potential loss.
Okay.
It can't be a way to actually punish the contractor for being late.
Right. So you can't just slap a huge figure in there to scare the contractor into finishing on time.
Exactly. And there's a really famous UK Supreme Court case, Parking I Limited v. Beavis, that clarified this. And if a court sees it as a penalty, it can be unenforceable.
Wow. So even though these figures are in the contract,
yeah,
they're not automatically set in stone.
Yeah.
There are legal principles at play. So listeners, if you're ever negotiating a contract, make sure that liquidated damages clause is reasonable and justifiable.
I couldn't agree more. And let's get into how these damages are actually calculated, especially with liquidated damages.
Yeah.
Because it's crucial to get that pre-estimate right.
Right.
And the RICS guide has some really fascinating examples.
Yeah, it talks about like a delayed hotel opening.
Yeah.
What kind of losses would you consider in that scenario?
Well, obviously you look at the lost revenue from room bookings,
Right.
But it goes beyond that because you've got unused facilities, potential impact on restaurant income, even reputational damage that you could factor in.
Yeah, it's not just the room sitting empty, it's the whole operation that's affected.
Absolutely.
What about a stalled office building?
So similar concept. The owner might have had to rent temporary space because of the delay.
Right. You'd include those costs. There might be, ongoing supervision costs for a site that wasn't productive yet.
Yeah. It's amazing how these hidden costs can add up.
Absolutely.
Sounds like documentation is key here, though.
Yeah.
You need to prove that those expenses were directly related to the delay.
Yeah.
Now, how do these damages actually get deducted? Is it like a big chunk of money withheld?
So it actually varies depending on the specific contract that you're looking at.
Okay.
The RICS guide actually analyzes different types of contracts. JCT contracts, NEC contracts. Ariosphal contracts, and they each have their own little nuances.
Yeah, that's actually what we're going to explore next. And from what I've seen in the guide, there are some pretty intriguing differences between these contract types.
Yeah.
Particularly when it comes to how they handle delay damages. It's almost like choosing the right tool for the job.
Yes.
You need to understand those specific clauses and mechanisms involved. Absolutely. And choosing the right contract for your project can really make a big difference in how smoothly things go.
Right.
Especially if delays occur.
So listeners, if you're feeling a little overwhelmed by all this contract talk, don't worry, we're going to break it all down for you right after this.
Picking up where we left off, let's actually delve into those contract types, and we'll start with the JCT contracts, which are very common in the UK.
Okay.
So the JCT standard building contract, for example, has no cap on liquidated damages.
No cap. So that seems like it could be quite risky for contractors.
Yeah, it definitely highlights the need for accurate pre-estimation and solid project management, making sure you're on top of things. The JCT minor works contract operates similarly, but doesn't allow for partial possession.
So you can't just hand over completed sections as you go.
No.
The whole project needs to be done before they can use any of it.
Yeah, practically finished. Yeah, and this can, significantly impact the damages calculation as well.
Right.
And then you've got the JCT intermediate building contract, which kind of sits in between the two.
Okay.
And this one introduces named subcontractors, and it has specific provisions for liquidated damages related to their work.
So another layer of accountability within the project. That makes sense.
Yeah.
What about the JCT design and build contract? Anything unique about that one?
Yeah. That one has a clause stating that the total liability of the contractor for liquidated damages doesn't apply.
Wait, so no delay damages at all? That seems unusual.
Yeah, well, not quite, because there are other provisions within the contract that address delays.
Okay.
Like the third-party rights for purchasers and tenants schedule.
Okay.
So while the general liquidated damages clause might not apply, there are still scenarios where the contractor could be liable.
So it's a bit more nuanced.
Yeah.
It seems like each JCT contract has its own quirks.
It does, yeah.
Let's move on to the NEC ECC, the engineering and construction contract. This one sounded pretty flexible earlier.
It is. It's quite interesting because it lets you actually choose between liquidated and unliquidated damages.
Oh, wow.
So, it gives parties that flexibility to select what suits their project and their risk appetite. And it also has secondary options which allow for further customization.
Oh, so it's like add-ons.
Exactly.
Right. Okay.
You can tailor the contract even further. And one of these options actually relates to delay damages, and it can include provisions for interest on those damages.
Interesting.
Which not all contracts do. Now, if we move into the realm of international construction, you'll likely encounter FIDA contracts.
Right.
And the FIDA's red and orange books, which cover building and design build projects, respectively, both have provisions for delay damages.
How do they handle things differently?
Well, one key feature is that they set a daily rate for liquidated damages. So, longer the delay, the higher the cost.
Right.
They also have a maximum cap on those damages, unlike the JCT standard building contract.
So there's a limit to the contractor's liability.
There is, yeah, which can be a relief on those big international projects, but there's a catch.
What's the catch?
Even if that maximum cap is reached, the contractor is still obligated to complete the work.
Oh, so no getting off easy just because you hit that financial limit?
No, the show must go on.
The show must go on.
Yeah, and another thing is that FIDI contracts allow for other damages to be inserted, meaning, parties can add clauses to address specific risks or losses beyond just that standard delay damages provision.
So there's room for customization even within these standardized international contracts?
Yes, definitely.
I imagine all these different contract types and clauses can be a bit overwhelming.
It can be.
For people.
Yeah.
So what's the most important thing for our listeners to remember when it comes to, navigating this landscape?
I think it's crucial to really carefully review the specific contract for your project and pay close attention to that language around delay damages. You need to understand the calculation methods that are being used. Be aware of any caps or limitations on liability. Don't just, skim over that legal jargon.
Yeah, knowledge is power, right? So especially when dealing with contracts.
Yeah, it really is.
It's like having a map before venturing into uncharted territory.
I like that analogy, and remember that the RICS guide is a great resource.
Yes.
For, navigating all this complexity.
Yeah, absolutely.
Yeah.
Now, we focused on the details of these different contracts, but I think it's important to remember that some general principles and practical considerations apply across the board, right?
Absolutely. There are common pitfalls and challenges that arise regardless of the specific contract that you're using.
Yeah. So let's explore those and offer some guidance.
Yeah, that sounds good.
Because we've talked a lot about, the theory and the different contract types.
Yeah.
But I think our listeners would really benefit from hearing about some of the practical realities of dealing with delay damages. Okay, so we've covered these different types of contracts, but what are some of the common hiccups that people encounter when they're actually dealing with delay damages in the real world?
Well, one thing that comes up quite often is contractors challenging the amount of damages that are being claimed. They might argue that the initial estimate wasn't accurate or fair.
They're trying to get that cost reduced after the fact.
Exactly.
But wouldn't the contract have specified that amount beforehand?
It would have, but the thing is the RICS guide emphasizes that this kind of challenge, it rarely works.
Okay.
Especially if the employer, really documented their reasoning for that initial estimate.
So again, having that paper trail proves invaluable.
Absolutely. Now, another common issue is ambiguity surrounding the completion date.
Yeah, we talked about practical completion.
Yeah.
But what happens when even that's a bit murky? Because projects rarely go exactly according to plan.
You're right. It's not uncommon for the actual completion date to differ from, the initial projection.
Right.
Due to unforeseen circumstances or changes to the work scope.
So how do you handle that discrepancy if the date isn't clear-cut?
Well, the RICS guide suggests using the date of practical completion as the reference point for calculating damages, even if it wasn't formally agreed upon.
So it kind of acts as a default when things get a little fuzzy. That makes sense. Now, what about early possession? We touched on this a little bit earlier.
Yeah.
But I'm still curious about its impact on the final damages calculation.
Yeah, so if the employer can use parts of the project before everything is completely finished, it can really affect the final amount that's owed.
So if I'm understanding this correctly, the damages are based on the value of what's not finished yet?
Yes.
But if the employer is already utilizing parts of the project, then that value decreases.
Exactly. And the guide actually gives a really helpful example. Let's say the delayed portion represents 40% of the total project value. If the employer takes possession of that section, the damages would be reduced proportionally.
Interesting. So that's almost an incentive for the contractor to hand over completed sections.
Yeah.
Even if the whole project isn't done yet.
Yeah, it can be a really smart strategy.
Right. Because it could potentially save them money in the long run.
Absolutely. And it can really help avoid those disputes.
Speaking of disputes, one thing that the guide highlights is that just because a contract includes liquidated damages, it doesn't mean that the employer automatically has the right to deduct the full amount.
That's right.
Really? I thought that was the whole point of having those pre-agreed figures.
It's a common misconception, but there are situations where UK law, specifically the Housing Grants Construction and Regeneration Act 1996, might actually require the employer to follow a payless notice procedure.
Okay, things are getting a little technical here.
Yeah.
Can you explain that procedure a bit more? What does it involve?
So essentially, the employer has to formally notify the contractor of their intention to deduct those damages and provide a detailed breakdown of the amount. So it ensures transparency and allows the contractor a chance to respond.
So it's not just a free-for-all on deductions.
No.
There's a proper process.
There is.
That needs to be followed.
Yeah, and the RICS guide really emphasizes that, failing to follow these legal requirements could actually prevent the employer from recovering those damages.
So that's a crucial reminder for anyone on the employer side.
Yes.
Dot your I's and cross your T's.
Yeah.
And what about the contractor's perspective? What if they disagree with the deduction?
Well, that's where, those dispute resolution mechanisms come into play. Most contracts will actually outline procedures for mediation, arbitration, or even litigation if necessary.
So there are options to try and resolve things before heading straight to court.
Exactly.
It sounds like open communication and a really clear understanding of the contract terms are key to avoiding these disputes in the first place.
I couldn't agree more. Being proactive and addressing potential issues early on can save everyone, a lot of time, money, stress.
Great advice. Yeah. Well, we've covered a lot of ground today.
We have.
From the different types of damages and contracts to these practical considerations and potential pitfalls.
Yeah.
Any final words of wisdom for our listeners before we wrap up this deep dive into delay damages?
Yeah, I would just reiterate that, knowledge is power when it comes to these construction contracts. So
Yeah.
whether you're a contractor or an employer, understanding the nuances of delay damages can really help you navigate the process more effectively
Right.
and minimize the risk of those costly disputes.
Absolutely. I second that. Don't hesitate to seek professional advice when needed.
Yeah.
And remember, the RICS guide is a fantastic resource
It is.
with really practical guidance and real-world examples.
Absolutely. And as we've discussed, that clear communication and realistic expectations from the outset can really go a long way in preventing those delays and minimizing potential conflicts.
Excellent point. So listeners, stay informed, stay curious, and keep building amazing things.
Yes, great advice.
It's been a pleasure having you on the show today.
It's been a pleasure being here.
And that's a wrap on this episode of The Deep Dive.